Morning everyone and welcome to Aitken Partners. Thank you so much for coming bright and early today. There are some new faces but also familiar faces, and for those who do not know me, I'm Bao, a principal lawyer and head of the Asia team, and I will be moderating today's seminar. As many of you know, Aitken Partners has a long history of working closely with businesses, owners, investors and professionals across the Asia Pacific region. Our Asia team was established to provide tailored legal support that not only bridges language and cultural differences, but also helps clients navigate the complexities of operating and investing in Australia with confidence. So today's session is designed to unpack some of the emerging legal challenges and opportunities we're seeing for Asian-owned and operated businesses in Australia, from commercial contracts, corporate restructuring to employment compliance, dispute resolution and regulatory obligations. It's a rapidly changing landscape, and understanding these legal fundamentals can make all the difference when it comes to protecting the client's investment and positioning client's business for long-term success. I also would like to take this opportunity to thank our presenters and my colleagues for sharing their expertise today, and thank you all again for joining us this morning. There are a lot of content to unpack, so if there are questions, we would answer it at the end. Of course, if there are any sort of other questions, please just hunt one of us down after this seminar is over. We'll provide you with our contact details and happy to answer your questions then. Now, to introduce our panel, first we have Zoe Zhao, Senior Associate in Commercial Litigation and Insolvency. Zoe is a Senior Associate in Litigation and Insolvency team and a key member of our Asia advisory practice. Her background includes advising on insolvency matters and acting for Mandarin-speaking clients in joint venture disputes and property loan structures. Zoe's familiarity with the Asian language clients and cross-border issues make her insight particularly valuable for us and also the clients. We also have Jenny, who's a lawyer in the litigation team and part of the Asia advisory. Jenny has experience in commercial law and litigation and have worked at the Supreme Court of Victoria on complex lists, including the corporations winding up and oppressions list. She is also deeply connected to the Asian Australian Business Community, a committee member of the Asian Australian Lawyers Association, and understands the cultural nuances of how East Asian businesses engage with law. And then finally, we have Isaac, an associate in the litigation and insolvency team with a rich international background. He was educated in both Australia and South Korea and previously worked in the US and the Korean legal environments. Isaac brings particular strength to our Asia advisory team by helping clients navigate the intersection of Australian, US and international law, and is also fluent in Korean. His global outlook and Asia-facing credentials make him a strong voice on legal issues affecting Asian businesses. Please join me to welcome our panelists. So the first topic focuses on property and leasing, which is a key area for anyone managing business premises or investment properties. Whether you're a cafe owner or a boutique retailer or commercial landlord, your lease is arguably the single most important document governing your business premises. So today, in the first part of the session, we're going to be unpacking the Retail Leases Act and arming you with practical strategies to avoid disputes and secure the best terms. We'll look at common traps and what can actually be negotiated, how to manage costs like rents and outgoings, and the essential steps to take if there is a potential dispute. So Zoe, up to you. For business owners leasing commercial or retail premises, what are the most common traps or misunderstanding under the Retail Leases Act?
Thank you, Bob. I think it's fair to say that the Retail Lease Act generally protects tenants, but I would say there's two very common things that can be missed out. The first thing is the scope. So not every commercial lease is a retail lease. So the Act only applies if the lease is a retail lease. So that means the premises are used for things like sale or hire of goods or provision of services. And if you fall outside that scope, then you're not protected by the Act. The second big thing is disclosure. So under the Act, the landlord must provide a disclosure statement within 14 days before you enter into a lease. And that also includes an estimated amount of the outgoings. Some tenants might rush into signing a lease without having received the disclosure statement. That might mean that you have waived the right to terminate the lease because of the failure to receive a proper disclosure statement.
So Zoe, you and I both see a lot in our daily practice when assisting Asian clients. The client might come to us with, say, some instructions to prepare a commercial lease, but in essence, it's actually a retail lease. So what are some sort of tips that you have to help that particular client?
So I would say you would need to think about the key terms of what you want in your lease. So most of the standard fundamental clauses in the lease is usually not going to change, but you can absolutely negotiate the commercial terms or the special conditions. So for example, you might want to negotiate as a tenant the rent review mechanism. So whether you want to change it from something like less of market or CPI, less of CPI or 5%, you might want to change that to something like fixed at 3%, for example. Another big thing is the permitted use of the premises. So by widening the definition of permitted use, it might be beneficial for your businesses down the track. Another thing is the make good obligation. So it's very important for tenants to know what's their make good obligation. Some leases might have very strict obligations that require tenant to incur so much cost to bring the property back to a brand new condition, for example. You might want to negotiate that to something like you can make payment in lieu or just have a very reasonable obligation to make it tidy and clean.
So something that Zoe touched on is quite of importance, and it does affect a lot of our Asian clients, which is permitted use. Something that potentially an Asian client needs to consider as well is whether or not their suggested permitted use is legal, and it may be that certain planning schemes prohibit certain use being made, and without the application for a planning permit, you actually can't operate your premises under that particular permitted use. And then, as Zoe had said earlier, when it comes to the actual retail lease provision, it needs to be a retail premises. So consider whether or not the actual business is actually providing goods and services to be able to understand whether the retail lease is actually going to apply.
Another thing I wanted to add is that most landlords would most definitely ask for a personal guarantee if you're a tenant and you're a company. If you can't remove that, try to negotiate to limit your obligation as a personal guarantor, which is the director of the company. So for example, you might want to negotiate to say that you're only personally liable within the first 2 years of the lease, or you might want to limit your personal liability to a capped amount, for example. Those negotiations or changes to limit your personal guarantee can be very important down the track.
I'm going to go a little bit off, but hand the microphone to one of our other guest speakers and give it back to you. But just based on your daily practice and experience, Isaac and Jenny, is something such as a personal guarantee common within the Asian sort of clientele, Asian businesses?
Yes, I believe so. Personal guarantees, I feel like a lot of the Asian clients that come to me when they first get into the business, they just want to get the ball rolling, so they end up just signing a bunch of documents where it says to sign, and they end up doing that, not reading it, not knowing the consequences, and giving personal guarantee, of course. Even the company, let's say, goes into financial debt later, the creditor could still come after you personally. So it has very high consequences, and everyone should be aware of that before signing it. It might be a page at the end of the contract, a long contract, where they just kind of sneak it in and say, hey, you're personally liable, but the person who's signing it doesn't actually understand the full meaning of the effect that it could have on that person personally.
Jenny, do you have anything to add?
I think what Isaac has said is definitely true. is extremely common, I think, not just with Asian businesses, but businesses in general. And they can be a lot wider ranging than you expect. You know, you could be covering things you didn't know you were covering. So they're definitely clauses to read and consider carefully.
Yeah, so definitely negotiating whether or not your client provides a personal guarantee is of importance. There could also be other suggestions where other individuals be provided with personal guarantees on behalf of your client. That may be something as well. And if you're particularly dealing with foreign residents, if you're acting for a landlord, please also consider whether anybody who is an Australian citizen or permanent resident may be able to provide a personal guarantee on behalf of a foreign tenant, because you want to make sure that you're going to be able to actually enforce rights under the lease if there is a breach of lease in the future. So Zoe, back to you. How can business owners best manage rent reviews, outgoings and renewal options to avoid future disputes?
So in terms of rent review, most of the rent review clauses that we see is based on market review. So it's very important to have very clear clauses in the lease that sets out the mechanism of appointing an independent valuer when it comes to market review, and also very clear and precise obligations as to how to share the cost of that independent valuer. And in terms of outgoings, it's good to know that the landlords bear a lot of the obligations under the disclosure of outgoings. So for example, 14 days before you enter into a lease, the landlord must provide a disclosure statement. And after entering into a lease, the landlord have to provide a written statement of outgoings within 3 months of the end of every accounting period. So that is very important, and that's where we see most disputes arise. Because if the landlord fails to provide that written statement every accounting year, then the tenant can refuse to pay the outgoings that they ought to have paid. So that is a very common dispute that we see in terms of retail lease disputes. In terms of renewal options, I would say as a tenant, it's very, very important to know your notice period specified in the lease. So it's usually 3 to 6 months before that term expires. And it's always good to exercise your renewal option by way of posting your correspondence by register post to the address specified on the lease. I would say don't always rely on email, because sometimes the lease requires delivery of that notice by register post only.
So Zoe, I know in your practice you've assisted a lot of Chinese clients when it comes to negotiating these sort of lease terms and sort of issues. And language barrier is obviously something that pops up. Is there any sort of tips that you may have for somebody who's probably doing this for the first time, they're a first time tenant, any sort of tips that you may have?
I would say if language is a hurdle for you, and you're about to enter into a very complicated, very long document that might bind you for the next 5 to 10 years, the first one is definitely don't negotiate through the agent, because you don't know who they truly act for. And it's always good to engage a solicitor from the start to negotiate the terms and to explain to you what you are signing up for. The second one is don't rely on verbal agreements. Never rely on verbal agreement, I would say. Always have something in writing, because in Australia, the property law is very, very strict on having a very concise, very clear written communication. So make sure that when you have something in writing, you also engage a solicitor to advise you what that means. Because sometimes the legal language can be very complicated and twisted, and it might cause misunderstanding.
I guess from an Asian sort of culture perspective, we often see that, you know, a handshake deal or a verbal discussion tend to be honoured, and perhaps that is something that, you know, what you're saying is under Victoria's property law and retail lease scheme, it's actually very strict, right?
Yeah, that's right.
Okay, so if there was a dispute that was to occur with the landlord, what are the practical steps before escalating it on behalf of a tenant?
So when there's a dispute, the first thing is always to put something in writing. So you would want to specify in writing the breach, and with reference to specific clauses or the specific sections under the Retailers Act, and also provide a deadline for when that breach should be remedied. And if that does not happen, then the next thing is always usually going to the Victorian Small Business Commission, so VSBC. It's a compulsory step before a matter can go to VCAT for retail lease disputes. VSBC is a channel that provides very fast and affordable revenue for retail lease disputes. It's usually held by way of mediation. And it's always good to have the matter resolved with VSBC as opposed to going to VCAT to incur further costs.
So I know with a lot of my clients that additional step by going to the VSBC is something that they never have heard of or familiarised themselves before. A lot of them, maybe through their friends or family members, assume that if there is a dispute, you immediately sue somebody and you go to VCAT or the courts to try to get an outcome. What do you have to say to a client to help them better understand that there is this additional process in place?
Recording in progress.
As someone that practices in litigation, I always tell my client that unless it's absolutely necessary, don't sue someone or don't go to the court. Because court is very expensive, it's very time consuming, it's very stressful, and you never know what's going to happen because you are handing a matter to someone like a judge who have all the say to your case, and you might have a 100% winning case, but something surprising might always happen at the final trial, so you never know what's going to happen. So if you can resolve the matter by way of a mediation, when you still have the matter within the control of your hands, then we always recommend to go through that route first. And VSBC is a very, very good opportunity, a very good platform for retail lease disputes. It's not something that's available for any other types of litigation. So I would say if you can take that opportunity, definitely do that.
Thanks, Zoe. And from the landlord's perspective, what are their obligations around disclosures and maintenance, and what are the common disputes that you see?
So for landlords, as I briefly mentioned before, there's a disclosure obligation. So I guess the key things for landlords to know is, first of all, before you enter the lease, 14 days before the lease is entered, you have to provide a disclosure statement. And after you enter the lease, every single accounting period, within 3 months of the end of that accounting period, provide a written statement of outgoings to your tenant. So that's the most important thing for landlords. The second one is in terms of maintenance. We see a lot of disputes around that area as well. So the Act says that the landlords are responsible for structural elements, so things like the roof, the walls, the air conditioning, and so only the damage to those structural elements are caused by the tenant. Otherwise, it's always the landlord responsible for those expenditures. A very common dispute here is around air conditioning. So whether the air conditioning requires a replacement, which usually falls under the landlord's obligation, or whether it just requires a routine servicing, which usually falls under the tenant's obligation. Sometimes this dispute just cannot be avoided, but it's always good to have clear obligations in the lease as to what falls under the tenants and what falls under landlords.
Thanks, Zoe. That was a great overview of how small oversights in leasing can create major problems for clients in the future. So we're now going to shift our focus to the broader commercial and corporate responsibilities that underpins every business, including Asian businesses. So Jenny, after you, what are the key legal responsibilities directors should understand when managing an Australian company?
Thank you very much, Val. And the core duties stem from the Corporations Act, I'll group them into three general categories. First is the duty to act in good faith and for a proper purpose. This is the overarching duty to act in good faith in the interest of the company as a whole. I think one key point that directors forget, and that's directors of all cultural backgrounds, in particular Asian businesses, is that your business is a separate entity. It's a separate legal person that you owe responsibilities to. This can be a difficult concept to grasp for people who don't come from experienced business or legal background, the fact that your company is its own entity. Many of the legal issues we see, I think, stem from people seeing their companies as an extension of themselves, not as a separate entity with its own interests. The second is the duty of due care and diligence. Directors must exercise their power with care and diligence of a reasonable person. This means being informed about the business, including attending meetings, generally knowing the finances of the company. A common excuse, I think we've probably all said it, is people can simply say, you know, I didn't know. And I saw this at the court all the time. I didn't know about this duty. I didn't know about this. I didn't know about that. You can't rely, you can rely on expert advice and expert employees, for example, your bookkeeper. These duties that you have are not, you can't delegate them to somebody else. You've got to keep an eye on it yourself. Thirdly, there are specific statutory duties. There's quite a few, and I won't be able to cover them all today. But most critical is the duty to prevent insolvent trading. This means the director must not allow a company to incur further debts if the company is not able to pay their debts as they become due and payable. As you might know, insolvency is its own area of law, and it can be quite difficult to figure out when it's insolvent. But you can be personally liable for any debts incurred while the company is insolvent, and it's quite common for liquidators of companies to pursue directors personally. Like recently, I had one of our clients saying, well, why are they pursuing me? My company has no money. Well, there are many ways your creditors, the ATO, etc., can get a hand of your assets, so be careful of that. There's also a duty to keep accurate books and records and retain them for 7 years. Directors also have a duty to keep their company details on ASIC correct. So I dealt with a lot of statutory demands while I was at the court. A statutory demand is a formal written notice to pay a debt. A company has strictly 21 days to comply, negotiate a settlement, or contest the debt at the court. If they don't do this, the creditor can assume that the debtor company is insolvent and get the company wound up. What would often happen is that companies would fail to update their address or put demand in a drawer and ignore it. They would then miss the deadline, end up in the wind-up list saying, I didn't know about this, why didn't no one tell me, why didn't no one email me about this? Well, unfortunately, they've served you in your company address, but you forgot to update it, which is obviously a problem. A small debt of over $4,000, which is the statutory threshold for SAP demands, can easily balloon into a much larger debt. Nicole and I recently had a matter like this, where you as a company owner could be liable not only to pay your own legal fees, but also the legal fees of your creditor. Another duty is not misusing your position or information that you've received as a director, especially to gain an advantage for yourself or your family members in detriment to your company. These duties should not be taken lightly. I think, for example, recently one of the other lawyers at the firm had a matter where an employee signed a document making them the director of the company, just so it was easier for them to sign documents for the company, because their boss was often absent. When the company got into some legal trouble or some trouble with the ATO, they received, I believe, a director's penalty notice, making them liable for certain unpaid company tax debts, when in reality they were just an employee who unfortunately signed a document without knowing the real implications of this. Whilst extremely rare, breaches of directors' duties can be prosecuted criminally and can result in imprisonment, although that has almost, I think, very rarely happens, and you can be disqualified for managing a company. I know that everything I've said also applies to officers of the company. There's a technical definition of this, but this can include people with significant decision-making power. So just because you're not the on paper director of the company, it doesn't mean a court can't consider you a shadow director or an officer of the company.
So a lot of these duties and even the concept of the company being its own entity is somewhat a complex concept for somebody who is probably doing business for the first time. We often see that with our Asian clients. I'm probably going to give it to any of you to answer this next question, but what are the sort of common strategies we as lawyers can implement at the beginning to kind of help the client navigate and understand these sort of complex concepts?
One of the things that I like to do is kind of create a checklist for my clients. So, you know, what their duties are. And I tell them all the time that you can't really, if you're the director, you're the captain of the ship, and if anything goes wrong, you're going to be blamed for it. So you can't just rely on your accountants to lodge, the ATO lodgements in time. You got to check. You got to be proactive. You got to see actually what's happening with your company, what your duties are. Sections 182 of the Corporations Act. You got to be aware of those things. So I like to create a checklist for my clients to know what their duties are on a high level, and if they have more questions, I like to dig deeper into it. But also the checklist will vary depending on the kind of business you're running. So I like to kind of just get a checklist for them to remind them of their duties and what their obligations are.
On a similar vein, we've heard clients say to us, it's my company, it's my money. Well, the money is actually in the company's account. How do you navigate helping a client of that nature to understand they're two separate things?
Is this a question for everyone?
Yeah, for everyone.
Yes, fair enough. I think
When it comes to these things, just be really practical. I think you can't just withdraw money from the company's account whenever you feel like, whenever you need to pay for your family's dinner or whatever. You can't just use company's credit card. You gotta actually separate it out. So just think of company as like a separate person, and make sure that there's no real ties between your personal life and what's going on in the business of the company.
Thanks, Isaac. Jenny, back to you. Many small business owners act as both directors and shareholders. What are the main risks if they don't separate those roles properly?
I think it's linked to what we previously said, but this is extremely common. I'd say it's more common than not. But you must understand the director owes duties to the company, the shareholders own the company. So as Isaac has stated previously, people have difficulty separating interests. A classic example is using company funds for personal spending. This happened in Marcel Plastering Group, where a shadow director, not the actual director, put money into his personal account and his, girlfriend's account. He was prosecuted and was given a good behaviour bond on top of having to pay back all the company's debts. Another classic example is a loan to a family member or an investment into another company you're personally linked to. It's actually not financially advisable. These things can all occur without anyone noticing, but when the company fails, these decisions can be scrutinised by a liquidator, being a person that often comes in after a company is shut down or wound up to basically investigate everything and sell off the assets of the company to pay creditors. Proper documentation, board meetings, proper accounting in particular, formal disclosures can help mitigate any of these risks. One thing to consider is also other shareholders. I imagine a lot of Asian businesses in particular tend to be family businesses, especially on the small business end, where there could be, multiple shareholders with different ownership stakes in the company who may not actually, have everyday management. They may not be in charge, but they could still have rights under the law. One option open to shareholders is Section 232 of the Corporations Act, otherwise known as shareholder pressure proceedings. I used to deal with a lot of these at the court. I like to think of them as divorce for companies, and there's just as many tiers and personal and personal gripes that can come up in these, especially at the mediation stage, and they can become very expensive. So a court can make orders in a repression proceeding where the company has taken actions that are contrary to the interests of the shareholders as a whole, or oppressive, prejudicial, or discriminatory against a particular shareholder or shareholders. This can include a minority shareholder. For example, say somebody owns 10% of a company that paid in, but they're not involved in everyday business. They still have that 10% shareholding, and when they're not giving a share of the profits, when they're not given access to the books, they can take action against the company and the director. I think a particular common solution is the removal of the director, purchase of shares, evaluation, even liquidation of a company is possible when all the shareholders can't agree on what to do next.
So how can businesses protect themselves in situations, during economic uncertainty when extending credit or trading with other entities?
I think risk mitigation is the most important thing. Do your due diligence. Don't rely on historical performances or friendly relationships, which is, I think, something that people in the Asian community can do, tend to do a bit more than others. Have a look at how much that person owes you, whether you've had to stop work previously or refused to deliver products. Second, make sure you have robust terms of trade and ensure your invoices and contracts clearly specify payment terms, interest on overdue debts, and mechanisms for dispute resolution. Talk to a lawyer about getting a good pro forma contract. This is something that you do often. If you're going to lend somebody money, don't assume the contract you've written up yourself will cover you, no matter how clever you might think you are. An example I've dealt with recently is somebody loaned somebody money. They thought they were quite savvy and wrote up their own contract, but they were very surprised when they found out they couldn't claim the legal cost, or all the legal costs of pursuing the debtor. Also, as we mentioned before, personal guarantees and indemnities are also important to get, especially if you're borrowing money, offering somebody a service. Obviously, this can be negotiated, but it offers an alternative path for recovery if the company you're doing business with fails. There's also security and the PPSR, which is the Personal Property and Security Registrar. This is extremely complex area of law, and I won't go into detail about it, but if you're in the business of selling goods on a retention or title basis, which basically means you keep the legal ownership of the goods until buyer pays in full, or you're hiring or renting expensive goods and equipment, or selling valuable second-hand goods, and you're not using the PPSR and you don't know what it is, you should definitely get some legal advice about that.
So in the event of cash flow issues or insolvency risk, what warning signs should directors look out for, Jenny, and when should they seek legal advice?
As I previously stated, a company is insolvent when they are unable to pay their debts as and when they become due and payable. The warning signs are pretty classic, and every director should know their own business. Continuous reliance on short-term funding, loans from family, bank overdrafts is one classic sign. Post-dated checks, constantly pushing back deadlines, demands from the ATO and creditors. The ATO in particular, as Isaac would know, as he often helps with these matters, is one of the big players at the federal court when it comes to winding up companies. If you go to the winding up list down at the federal court, you'll see the ATO, the ATO, the ATO, the ATO, versus I think every director in the company, every director in the country. I think another classic sign is suppliers wanting cash up front and refusing to supply you as a director until your debts have been paid. You should seek advice the second that you have reasonable grounds to suspect the company is insolvent, and you should immediately stop incurring new debts once you have that even inkling of a reasonable ground in your mind. You'll need to contact an insolvency practitioner or a lawyer to get some advice. Acting quickly opens up more options. For example, small business restructuring, which is a simplified formal process where a small business restructuring practitioner will help a director set up a plan to pay their creditors while the director remains in control of the company. The creditors may end up accepting a plan that greatly reduces your debt or allows the company more time to pay it. I think Isaac in particular has had great success with a small business restructuring with one of his Korean clients. So it's definitely an option there, especially if you get in early and you meet the criteria. Another option is administration, where an independent insolvency practitioner takes over the business, so that the director would lose control, try and save it, and to achieve a better return for creditors than if it was immediately liquidated. When the company is liquidated, all its assets are sold to creditors, which means there could be nothing left for you as a business owner or as a director. After the liquidator has taken their fees and every creditor has had a bite of the proverbial pie. What you don't want to do is to procrastinate, ignore demands, ignore the ATO, and wait until one of your debtors tries to shut down your company. Then to only have a liquidator come, ask for your books and records, and crawl for every transaction you've made the last couple of years. That's really best to be avoided if you can.
So the next question I have will require all three of you. It's not a trick question, but it's going to require all three of you to draw on your experiences in the most sort of cases that you've worked with. But so you've worked with clients across different jurisdictions. What differences do you notice between how Asian and Australian businesses approach corporate governance? So Jenny, I'll start with you, and then maybe you can pass the microphone to Isaac and Zoe for their comments as well.
So I think Zoe's previously touched on this. With rental laws being extremely rule-based, the same as with Australian corporations rules, Australian corporation law. I think small business owners in particular, and business owners with a background overseas may not know these rules. And nobody is going to tell you what they are. You're expected to know as director, which obviously often leads to difficulties, especially when dealing with business partners who do understand the rules. I find that to play within the rules, you have to actually understand what the rules are, or you're going to end up in trouble. I think Asian businesses in particular can conflate the business with the business owner, and conflate the interest of the business with the interest of the primary business owner or dominant shareholding partner. Decisions, I think, made in family business in particular can consider what's best for the family rather than what's best for the company. And directors might be shocked to realise a minor shareholder, a cousin from, I don't know, Perth or whatever, who doesn't run the business, who has no input into anything, actually has a legal avenue to take legal action against them. I think older generations of Asian migrants also rely heavily on cash and informal methods of communication, such as WeChat, which can make agreements, which can make it difficult when you're the lawyer and you have to trawl through thousands of pages of WeChat conversations to figure out what happened with the oral contract. When things go awry, it'd be much easier for everyone if there was a formal written contract and things were set out in stone. And I think I often find this, and my parents are immigrants from an older generation, is they have this idea of what's fair and what's morally right, and they think the law reflects that. Unfortunately, this is not always the case, and there's a conflict when it comes to business owners where you have an idea of what the law is, but that doesn't reflect reality. And as lawyers, it can be difficult explaining that to a client and explaining that, while it seems unfair for you, the other side have actually followed the rules. They've done what's technically legally right, even though it's not morally right.
Any comments from Zoe and Isaac?
So I've dealt with a lot of litigation files where a Chinese client might have been appointed as a director of a company, potentially for visa purpose. I don't think that visa exists anymore, but when it did exist, there's a lot of cases like that where someone that resides in China wanting to come to Australia, and one of the visa requirements is for them to be a director of a company that runs for, say, 3 years. I've dealt with cases where that happens. The person was appointed as a director, should continue to reside in China. The company got wound up. So there's usually another business partner in Australia actually running the business. So when the company gets wound up, the business partner usually go bankrupt, they don't have any assets, and the liquidator will usually start pursuing the person that resides in China because that person usually have those assets under their names. In those circumstances, there's effectively no real defense for that person, even though they've said they've done everything that they should have done according to the visa requirements. But the moment that you are appointed as the director of a company, you are someone that bears the statutory obligations under the Corporations Act. That's something that those people don't usually know until they are being pursued by liquidators for debts being incurred by the company. That can be millions of dollars, and they're pursuing that person for personal liability. So those are the cases that I deal with a lot, and I think those are probably the main area where I see Asian clients can fall into the trap when it comes to Corporations Act.
Isaac?
Yeah, just shortly, I guess really be mindful of what kind of information you're consuming. There's a lot of misinformation that, yeah.
Well, we still have the phone, so of course another crucial element in running a successful business is the management of people. So ensuring our clients meet their legal obligations when building a positive workplace culture. So employment law in Australia can be complex. So what are the key legal obligations that an employer who's operating a business and have employees need to be aware of?
Yeah, so employment law, I work on employment law matters from time to time, and I feel for the employers in Australia because I think the Australian law, employment law in Australia is very different to laws, for example, in Korea, because I come from Korean background, I work there, it's very different. And I feel for the employers here in Australia because I think the law here is heavily favors the employees rather than the employers, in my opinion. So I can't help but to compare because a lot of my clients are Koreans. And for example, workplace bullying, that definition in Korea and here is very different. In Korea, last time I worked there, the boss will yell at you if you provide incompetent work or if you're late in providing the work. That's just part of the culture. A lot has changed over the recent years, but they still kind of gently push you, I guess, to be better and to make sure that you actually make you understand that this is not how you do it. You gotta do better. It kind of as an encouragement almost, but here, anything, even little saying with the words, it could upset the employee, and they could actually go to the Fair Work Commission and say, I've been bullied by my employer. So the definitions are very different. So the key point that I'm trying to make here is just have a different mindset. You can't just bring whatever practice you had in your own country and try to adapt it here because you're going to get into a lot of trouble. And I feel a lot of the Korean clients who come to me, they say, I've been practicing like this, I've been running a business like this, but I'm like, you're living in Australia, you're not in Korea anymore. The culture is very different, the law is very different. And especially they tend to hire a lot of Korean employees as well. And within their little office or restaurant, they just feel like it's mini Korea, which is, in your mindset, it could really confuse you as a owner. And what I'm saying is you just need to have a different mindset when you're looking at these things. So that's one of the things I wanted to just kind of touch upon. And employers, you got to be aware of your obligations. Like, for example, you need to understand how to deal with the complaint that an employee makes. They have workplace rights and they have the right to make complaints about the workplace. So have a formal process to acknowledge and investigate the issues, such as documenting the complaint, gathering evidence, and speaking to all parties involved. you need to really advise on the outcome of your investigation to your employees as well. It is recommended that there's a professional HR manager or department within your business, but I understand that if it's a small business, you can't really afford to have a separate HR manager, or if it's a restaurant, there's really no HR manager there. And you need to really provide safe environment for your employees. So there are a lot of great trainings out there. I recommend not just HR managers to attend those things, but a lot of directors who wears many hats to attend to those trainings and actually learn about them. Another major thing that the employer really needs to consider, and what we have already touched upon this, is the importance of preparing an employment contract and have everything in writing. Have a proper written agreement. It goes a long way. It actually helps the employees understand their obligations as well, because they have a written contract before they actually start work. So it's a great way to prevent any issues in the future. So for example, I had a colleague who had a client, Asian client, who's a builder, and he really wanted a talented employee. And one of the perks that he offered was, hey, if you work for my company for 3 years, this company truck, it becomes yours. Like, I'll hand over the ownership. It sounded great, but after 2 years, the employee left with the truck, and of course everything was verbal agreement. Nothing was written, and I told my colleague told the client about all these risks of issuing proceedings in court and the cost of doing it, and he said never mind. The client eventually didn't go through with it, so do it. And another thing that I see a lot is a lot of these employers, they give too much credit to themselves. They think that they're lawyers, so they draft up this beautiful written agreement. And I had a client, I think, a few years back, and when I read it, I'm like, this doesn't make sense. There's a lot of grammar errors. It just doesn't make sense. There's actually legislation guiding these rules, which is going to override anything that the parties have agreed to. So written contract is, I can't emphasize enough about it.
So different cultures obviously will handle staff performance and termination differently, Isaac. But in Australia, how should an employer handle staff performance and termination to reduce the risk of unfair dismissal claims?
So to just briefly touch upon what unfair dismissal claim is a legal claim that employee makes against the employer for being terminated in a way that was harsh, unjust, and unreasonable, and is not a genuine case of redundancy. There are other claims similar to unfair dismissal, such as general protections. In order to reduce the risk, I think, again, you need to have a highly trained HR, or you as a director should train to know what your obligations are as an HR manager and how to best, take care of your employees. Perhaps you want to get some legal advice on this as well. Again, the importance of having a contract in place, because if, let's say, if the employee causes a serious misconduct, in the contract you can actually list out what are some of the examples that could constitute as serious misconduct. So it's very important to have a detailed contract in place. And what I will say to that is there's no pathway that guarantees you from being prevented from your employee bringing these unfair dismissal claims against you in the Fair Work Commission. But here are my key points to take away, I guess, is that before you dismiss anyone, there must be a valid reason for dismissal. Some of these could be outlined in the contract, and the case law refers to these as reasons that are sound, defensible, and well-founded. Another thing that you could do is provide a valid notice to the employee, which includes the valid reasons for dismissal. Make sure you give the employee enough notice, a written notice, and follow any policy or procedures that you may have in place. and allow an employee to respond to those valid reasons that you have provided, unless the contract allows you to immediately terminate the person, let's say it's for a sexual allegation of behavior or something like that, very serious. It might allow you to just dismiss it without actually giving a formal notice. But it's always good to give notice. Keep file notes, records, and journals, because that could be used later and, if it does go to Fair Work Commission. So in conclusion, before you open up a business, or if you have already done so, really spend some time implementing a workable system that works for your business. I say this to clients all the time. Things only become problem when it actually eventuates to a problem, to an issue. So don't think that this might not happen or something like that, because these things that you do to prevent or mitigating the risk in the future will become really handy if those issues actually arise. Yeah, this is what I have.
So I'm mindful of the time, but are there any questions from our audience or our online audience? Yes,
I like the thing about the different hats that a director, a shareholder, and a company have. It's a very valuable message. And I expect that director that likes to pay for his family meals from the company accounts would be aggrieved when the company sees his money the same way. So I was thinking it might be worth mentioning whether other ways in which directors have to reach into their pocket for the company might be not payment of superannuation. And there's also the criminal jurisdiction if they have not had a safe system at work, they can be criminally prosecuted, or if they engage in wage theft. And there's so many ways now that directors have to take on more responsibility than they used to. So that's a good message for people, isn't it? Well, it was more of a comment than a question.
Yeah, I think that was more. But thank you, Alistair. Is there anything else? Well, can I just really take an opportunity to thank our wonderful panelists for their insightful discussions across many different key areas of law that we see through property, leasing, corporate and employment law, and provided practical takeaways for our audience today. And please stay for more coffees and conversations. And like I said at the beginning, we're all here, so please hunt us down if you have any other questions that may be niggling in the back of your mind that wasn't discussed today, and will be available. So thanks everyone. Have a great morning.